Hello and a warm welcome to World This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notification for new videos. My name is Sheetal June, Associate Editor, latestlaws.com. I will be taking you through the significant orders and judgments passed by various courts in the country and some important international news from this week. Let's begin with Supreme Court this week. The Supreme Court has upheld a Punjab and Haryana High Court order quashing the Haryana government's policy of granting additional marks to its residents in recruitment exams. Terming the Haryana government's policy a populist measure, a vacation bench of Justice Abhay Oka and Justice Rajesh Bindal refused to interfere with the High Court order, which had held as unconstitutional the socio-economic criteria prescribed by the Haryana government to grant additional marks to certain classes of candidates in state government jobs. Justifying the policy, Attorney General K.R. Venkataramani had said that the Haryana government introduced the grace marks policy to give opportunities to those who were deprived of the security of public employment. The Supreme Court has held that a decision to continue with a person who had earlier done an unsatisfactory job can be taken to be a valid economic decision, but that by itself cannot be a reason for not applying the applicable clause of the insurance contract if such applicability is otherwise proved by cogent evidence. A division bench of Justice P.S. Narasimha and Justice Aravinda Kumar decided on a matter where there was a deficiency in the services provided by the contractor which led to the bridge to collapse even before it was completely built. This resulted in the death of 48 workmen also. The contractor was hired again by the NHAI for completing the remaining work due to various reasons. The Supreme Court has directed the Delhi government and the civic agencies to convene a meeting and discuss comprehensive measures to enhance the city's green cover while observing that people are feeling the heat as the tree cover is lost. A vacation bench of Justice Abhay Oka and Justice Ujjal Bhuyan said that it expects the Forest Department and the Tree Authority to keep a vigil on the activity of illegal damaging of trees in Delhi. Observing that brazen acts of tree felling in the national capital cannot be brushed aside lightly, the top court said a clear statement from the Vice Chairman of the Delhi Development Authority (DDA) about whether trees in the ridged area were cut on the orders of the Lieutenant Governor without its permission. Now let's have an overview of High Courts. The Karnataka High Court has ruled that the use of black money law retrospectively is unconstitutional as it quashed the criminal proceedings initiated by the Income Tax Department against persons connected to overseas bank accounts and firms which were closed well before the Black Money Act came into force. For the first time, the court has invoked Article 20 of the Constitution to squash law's retrospective use, which was enacted in 2015 to allow the taxmen to go after offshore bank accounts, properties and companies of resident Indians. The ruling would set a precedent for several court cases as many Indians sensing advent of such a law had either shut their bank account and companies before 2015. However, under Section 72 of the Black Money, Undisclosed Foreign Income and Assets and Imposition of Tax Act, commonly known as Black Money Law, overseas assets acquired years ago can also come under scrutiny. The year the tax office gets hold of the information is taken as the year in which a foreign bank account was opened. The Kerala High Court, while allowing a petition that challenged the order which was passed by an officer who never heard the petitioner's case, ruled that the doctrine "he who heard must decide" or "he who decides must hear" applies to statutory authorities, requiring the proper officer to individually adjudicate tax-related issues to uphold the principle of natural justice. It was also emphasized that Section 75(4) of the KGST or CGST Act mandates a hearing if requested in writing or if an adverse decision is anticipated to ensure fair tax determination. The bench expounded that the doctrine "he who heard must decide" or "he who decides must hear" applies to decisions made by statutory authorities but not to institutional decisions which negate the doctrine. For tax-related determinations such as unpaid or short-paid taxes, erroneous refunds, or improperly availed or utilized input tax credits, individual adjudication by the designated proper officer is necessary. If the officer who hears the case does not make the final decision, it would violate the principle of natural justice. The Patna High Court, while allowing an appeal filed against the order convicting the appellant under Section 498A and 302 of the Indian Penal Code passed by the Additional Sessions Judge, held that Section 106 of the Evidence Act would apply to those cases where the prosecutor had succeeded in establishing the facts from which a reasonable inferences can be drawn regarding the existence of certain other facts which are within the special knowledge of the accused. If the chain of circumstances which is required to be established by the prosecution is not established, the failure of the accused to discharge the burden under Section 106 of the Evidence Act will not be relevant at all, the court said. The single judge bench of the Andhra Pradesh High Court has awarded compensation to the deceased's major children who were dependent upon the deceased, while holding that deceased's major children dependent upon the deceased and not having an independent income will be considered as dependents for motor accident claims. The court relied upon the judgment titled Saria Verma and others versus Delhi Transport Corporation and others, in which it was held that when the dependents are 2 to 3, 1/3 probable income of the deceased is to be deducted towards personal and living expenses. The single judge bench of the Jharkhand High Court has held that a handwriting expert's opinion is not itself substantive evidence when such opinion is obtained unilaterally behind the back of other party without the intervention of the court. The veracity of such report is of little evidentiary value. The court observed that in accordance with section 311 CRPC, the court must call a witness for evidence if it believes that the evidence of such person will be necessary for a fair decision. The Telangana High Court has made it clear that educational institutions cannot withhold transfer certificates on the ground of a student defaulting on the payment of a fee. The court said that the certificates of students are not a lien to put them as caution deposit for the payment of dues. The court observed that the certificates are the property of the student. Justice Surapalli Nanda observed that the right of children to get the TCs from the schools to join another school for whatever reasons cannot be denied by the school authorities merely because the fees is due. Moving on to international news this week. WikiLeaks founder Julian Assange walked out of the Belmarsh prison in the UK after he was due to plead guilty this week of violating US espionage law in a deal that ended his imprisonment in the country and allowed him to return home to Australia. The 52-year-old agreed to plead guilty to a single criminal count of conspiring to disclose classified US national defense documents. Assange had been detained in the UK for 5 years as he fought extradition charges by the US, which sought to prosecute him for revealing military secrets. The UK government approved his extradition in June 2022. In 2010, WikiLeaks released thousands of classified US military documents during the wars in Afghanistan and Iraq, the largest security breaches of their kind in US military history. There were over 7 million documents that included diplomatic cables and battlefield accounts. The US Supreme Court on Wednesday struck down part of a federal anti-corruption law that makes it a crime for state and local officials to take gifts valued at more than $5,000 from a donor who had previously been awarded lucrative contracts or other government benefits. By a 6-3 vote, the justices overturned the conviction of a former Indiana mayor who asked for and took a $13,000 payment from the owner of a local truck dealership after he helped them win $1.1 million in city contracts for purchase of garbage trucks. In ruling for the former mayor, the justices drew a distinction between bribery, which requires proof of an illegal deal, and a gratuity that can be a gift or a reward for a past favor. They said the officials may be charged and prosecuted for bribery, but not for taking money or for past favors if there was no proof of an illicit deal. US prosecutors are recommending to senior Justice Department officials that criminal charges be brought against Boeing after finding the plane maker violated a settlement deal related to 2 fatal crashes. The Justice Department must decide by July 7th whether to prosecute Boeing or not. The recommendation of prosecutors handling the case has not been previously reported. In May, officials determined the company breached a 2021 agreement that had shielded Boeing from a criminal charge of conspiracy to commit fraud arising from 2 fatal crashes in 2018 and 2019 involving the 73X MAX jet. Under the 2021 deal, the Justice Department agreed not to prosecute Boeing over allegation it defrauded the Federal Aviation Administration so long as the company overhauled its compliance practices and submitted regular reports. Boeing also agreed to pay $2.5 billion to settle the investigation. In the end, we have miscellaneous news. The Ministry of Home Affairs has issued 2 standards of procedure under the new criminal procedure law, that is, the Bharatiya Nagrik Suraksha Sanhita (BNSS) as suggestive guidelines. The first one is to file 0 FIR and EFIR, and the other one is for audio and video recording of crime scenes. As per the SOP, an EFIR can be lodged by logging into the official police EFIR portal or police website, or may send the complaint or information to the concerned police station through any electronic communication. 0 FIR, on the other hand, addresses the critical issue of jurisdictional limitations that have historically impeded the swift initiation of criminal investigation. It will be mandatory for the officer in charge of the police station to supply videography recordings of the scenes of crime, recording of search and seizure information, cognizable cases, FIR, other orders of custody and disposal of property to the magistrate. The Bar Council of India has assured the bar associations and state bar councils across the nation of initiating conversation with the centre regarding concerns raised by them in respect of implementation of newly introduced 3 criminal laws. The council has urged them to refrain from protest or agitation at this juncture and taken upon itself to convey the concerns of the legal fraternity to the government. Concerns have been raised that several provisions of these new laws are perceived to be anti-people, more draconian than the colonial era law they intend to replace, and pose a serious threat to the fundamental rights of the citizen. Notable legal luminaries such as Mr. Kapil Sibal, Mr. Abhishek Manu Singhvi, Mr. Mukul Rohatgi, Mr. Vivek Tankha, Mr. P. Wilson, Mr. Dushyant Dave, Mrs. Indra Jaisingh, along with a large number of senior advocates and other advocates for several high courts and trial courts, have voiced strong opinion or opposition to the 3 laws. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.